started 117 or something, but the first week everything else was perfect. It wasn't the team brought it up. Agreed. You put it inside the set. This is covered in this butter. That's kind of weird. Yeah, I want to do that as well. I'm winging it. When these kind of things happen, I'm just like, oh, I got lucky. If you get confident, then you can try something more. How do you know?
Hi, AB. I'm in room S-1.06. Yeah, I plugged in my iPad into the system. I just discovered that I didn't connect the charger to get a power. So it's already connected, but my iPad will run out of time. I have 4 hours of teaching. So I was wondering if somebody could assist me to get a cable so I can at least be able to get power. No, so just the iOS charger, the wire. I have the plug. Yeah, I have the plug. Yeah. So no, I don't. Once I just get the wire, not the plug, I'll just plug the wire into my connector, right? And at the other end, I have a plug. I'll just plug it into the It's the iPad wire, the iOS wire. No, I think it's only one.
I'm not sure, but
Because I have been access in, it's only one charger that we use, unless you're referring to some old one. It's the, the small, yeah, yeah. Oh, thank you so much. I've really, because I haven't thought out straight, so yeah, thank you. I really appreciate your help. Huh? Thank you very much. Yeah. Okay. Yeah. Yes. We today we're talking about the body of law known as financial assistance for the purchase of shares. We deal with it because it's ubiquitous in these transactions, many transactions people do, and a lot of times it tends to act as a transaction spoiler because it may rear its head in a way that's not so obvious, and because of the consequences of triggering it, i.e. illegality, you just don't want to take that risk. I always say it's always good to have it on your checklist of issues. So no matter how far-fetched or remote it may seem, it's always good to have it as part of your checklist. Whether it's acquisition financing you're doing, debt financing, whatever the case may be, it's useful. So not just at a transactional level, but even from a point of litigation. Obviously, from the point of litigation, your ability to spot it can be very useful. Those I don't know if I've mentioned this. There was an arbitration that I was involved in where there was a purchase of shares through a share purchase agreement. So before completion, the vendor pulled out. So the vendor had basically signed an SPA, which is a share purchase agreement. But at the point of exchange or completion, the vendor pulled out, and the purchaser went to court and sought to get a decree of specific performance or damages. Now, between the date they entered into the SPA and completion, the purchaser was in control of the company, because what had happened was that they moved from a concession arrangement into a share purchase arrangement, right? So the purchaser was in charge of a concession and was managing the concession. And then they said, oh, you know what, it would be good if you own the shares. So that's why they did the SPA, the share purchase agreement, to be followed up with completion. Now, so in between the share purchase agreement and completion, the purchaser, whilst in control of the company, raised finance by pledging assets of the company. So they raised finance from a bank and pledged the assets of the company. And they thought that was normal. And so in the end, when the seller said, I'm no longer interested in going ahead with this deal, the purchaser took them to arbitration. So this is where I got involved. And one of my arguments was that there was unlawful financial assistance. And that came as a surprise because the lawyers on the other side were American lawyers, and in the States they don't have this. They don't have unlawful financial assistance. And, you know, so my argument basically was that there was an unlawful financial assistance. And so how does one make this argument? There was an agreement to purchase shares, right, as a matter of contract. Even though you've not gotten to completion, when you get to completion, that's when property changes, right? But as a matter of contract, there was a contract. And whilst you had an obligation to pay for the shares, you decided to pledge assets of the company. That pledge was assistance. you were getting assistance from the company in pledging the assets to a bank to raise finance. And that itself was unlawful. That's the financial assistance, right? And once that argument was made, I mean, in the end, it was settled, but they fell for it, right? And you can see how nobody would have realized this. In fact, I still remember the moment during cross-examination where some chap called Manwati, who was in front of me, and I said, you pledged these things? And he agreed, and I was just smiling to myself because he didn't understand the implications of what he was agreeing to. And so it was pretty clear. But the real interesting issue here was, even though there was unlawful financial assistance, what I was trying to do, which was to say that the illegality tainted everything. It didn't taint everything. It only tainted the pledge, right? You see, because when we go to the consequences of illegality, what does unlawful financial assistance really do? It's unlawful, right? But how far does the illegality extend? In this case, what is unlawful is the pledge, not the SPA. The SPA is not tainted. So long as you can exercise a power of severance to cut off the SPA, right, then the obligation of my client still remains. My client still needs to convey the shares. And all that is unlawful and therefore should be struck down is simply the pledge. But because, in a sense, I was able to make it look really larger than it was, they sort of fell for it. But in the end, as I said, the matter was settled. So that's just one example of how this comes up where it's not so obvious, right? And as I said, the reason why they did the pledge was because they were already managing the assets of the company. They had a concession. So they were there. They had a concession, which the concession had run 2 years. So they were always managing anyway. It was just business as usual. But what they hadn't realized was that that pledge could affect the agreement that they were now entering into. So I give that example just so that you understand. And if you look at a case like Charterhouse, which we'll talk about, where the issue there was the surrender of tax losses. And who would have believed that the surrender of tax losses would have amounted to financial assistance? But you see Hoffman telling us that it could be financial assistance. So it's not always so obvious. This is the point. You know, if it's so obvious, then people will spot it. But once you sort of bear that in mind, then I suppose it becomes easy well, I won't say easy to spot, but at least you have it in mind, and therefore you're more likely to spot it than not to spot it. Does anybody have any questions so far? Okay. So now there is a link between financial assistance. So here we're talking about a company giving financial assistance for the purchase of its shares. So there is a superficial link between this and equity financing, i.e. The capital maintenance rule, in the sense that we try to protect capital through the capital maintenance rule. So it looks as if the company is going to its treasury box and taking money out of its treasury box to give somebody assistance to buy its shares. It looks as if it is the same thing, and this is how the early judges approached it. They saw some kind of equivalence between capital maintenance rules and the rules on financial assistance. But it's misleading to see it that way, because we know that you can give financial assistance in such a way as to not to cause any movement on your balance sheet, right? So with no depletion of any assets, so your balance sheet is not moved. And yet the court would still say it is financial assistance. So take the case of a company giving a guarantee, right? That has not affected the balance sheet if the guarantee is not called. So that basically just tell us that it's not exactly capital maintenance. We're dealing with something slightly different, and we're dealing with something that perhaps has many. Is that us? Oh, okay. Okay. So we're dealing with a situation where you have market manipulation rules, right, coming in. So if you think about securities regulation, we don't want, you know, we don't want any kind of market manipulation, and therefore we see financial assistance as part of that. I'll give you an example. If you think about the Guinness and Distillers takeover, Guinness was trying to take over Distillers, and it then gave certain third parties who were concert parties of Guinness certain indemnities to encourage them to buy the shares of Guinness. So the idea was that if you give these banks indemnities to buy our shares, Guinness, then the share price of Guinness will go up. And if the share price of Guinness goes up, and Guinness is trying to take over Distillers and using its paper as the currency for the acquisition, then the target company, Distillers, would find Guinness's shares attractive. That is market manipulation. And right, so that's securities regulation rules coming in. So it's market manipulation facilitated by the giving of financial assistance. Right? So there is that, and there is a case I was involved in, which is reported. I'll try to remember to send you the citation, or at least extracts from it, perhaps, where something similar occurred. This was a few years ago, about maybe 4 years ago, where a bank literally was buying back its own shares. So they were using depositors' funds to buy back its own shares, and they were also giving certain people finance to buy the bank's shares. So essentially, they were engaging in market manipulation, and the argument was that, so I basically dealt with the capital maintenance bits and financial assistance bit. So the argument was that the bank is engaging in financial assistance, and the bank's defense was that they were simply making loans to third parties, right, which is what banks normally do in the ordinary course of business. But it's just that when you make loans of, I've forgotten the amount now, we're talking about millions of dollars, right? And with a lot of times no security, just channeling money to these guys. It was very difficult to say that this was in the ordinary course of business. Now, if you look at the law on financial assistance, you'll see that they're setting safe harbors. So there is a safe harbor for a bank making loans in the ordinary course of business. So what they were trying to do was to force their case within this, but the quantum was enormous. I think so. If I'm going to send this to you, I'll direct your attention to that, to see, could you literally squeeze this in? And the judge basically said, this was unlawful financial assistance, right? So what you're seeing here is, I suppose, in that sort of situation, you're seeing the directors taking advantage of shareholders, right? So there are issues of shareholder protection. There are issues of market manipulation, which is slightly different. There are issues of doing things which will be in fraud of creditors, and therefore that's similar to capital maintenance. Do you see? So what we have is a law that is supported by a multiplicity of underlying themes, right? Now, if you look at I suppose what I've done here in the background is really just to kind of state this. I said, since superficially the provision of financial assistance resembles a purchase by the company itself, then we basically prohibit it. And then I say, because what if the loan is not repaid? In which case your balance sheet changes or is affected. But then, on the other hand, you may have, other drivers which obviously would affect shareholders' interests. And obviously I don't expand on it there in the way I have in the course of this class with the examples I've just given, but that's really the point. Then if you look at how the law really developed from 1929, you know, you would see this is after the First World War, and there were a lot of cases which came out of that era, and the judges actually thought this was really wrong. They see, interestingly, if you look at the statement in VGM Holdings, it's referring to this common practice here of buying the shares of a company, having a substantial cash balance, and arranging matters that the money was lent by the company to the purchaser. So you get the company to lend you money, to give you a bridging facility, and then you buy the company using its own resources. Now, if that's the case, let's test it this way. So imagine you have a scenario where a company has a huge cash balance. You take a loan from a third party, and you then buy the company, and immediately cost the company to pay a dividend, and then you use the money you've got to pay off the bridging facility. You can do this within a month, weeks. Would there be financial assistance? Would it be embraced within the mischief that VGM Holdings is talking about? So you see the target company, it has a big cash balance, right? You say to a bank, give me a bridging facility, I'll liquidate this within 2 weeks. You buy the company, you quickly pay out a dividend, and then you liquidate the loan. Would there be unlawful financial assistance? Would this be embraced within this? Yeah.
I would say no, because the creditors are protected through the dividend process, and only distributable profits are able to be given up to the shareholder. Yeah. And so they are not really in danger.
Yeah. So presumably, I suppose that would depend on what value sort of underpins your idea of the law. So because you're focusing on just the creditors, you're saying creditors are protected, and you would give this answer in all circumstances. I just want to be clear. You'll give this answer in all circumstances. Basically, you're saying no value is affected, no other value is affected. Because remember what we did earlier is that we were trying to explore the underlying values which underpin this law.
I mean, it depends on the purpose we are pursuing.
The purpose is what I've just stated. Imagine a smoking gun comes out in the form of, they did discovery, a letter comes out where the purpose is clear. We will take over this company with a huge cash balance and pay off the loan. It's there. So the purpose is clear. So what would the answer be?
I think it would be financial assistance.
It would be financial assistance.
Yeah, I think the whole point of financial assistance is simply to stop the company from assisting someone to purchase shares, no matter how that affects the company. Because you're protecting, it's not just the creditors' interest you're going to protect the other shareholders as well. And there's so many different interests we need to protect through financial assistance.
But so many interests. Okay, so you'll accept that creditors are not prejudiced in this example. So how are shareholders prejudiced? Did the shareholders not enter into a contract with other shareholders that the company can pay a dividend when it has sufficient distributable profits? If the company has sufficient distributable profits and the dividends are paid to everybody in accordance with the contract, so how are shareholders prejudiced? Yeah, but they are not. That's the point. So if creditors are not prejudiced, as he said, shareholders are not prejudiced. I know you added other things in the mix. You said many other interests in addition. There's only one other one, which is market manipulation. There is no market manipulation here. It's not a Guinness and distillers type scenario. Then why should we prohibit it? Why should we apply a regime of strict liability in the service of no useful purpose, because there's no useful purpose here.
Let's suppose the shareholders didn't want to give up their shares to the purchaser.
They're not forced. Oh, they're not forced.
If you finance, if you give financial assistance to, for example, like in a management payout, to facilitate the acquisition of the company by a director, for example. What if, like, a shareholder doesn't want him to acquire the company?
Well,
you're doing it at the detriment of the shareholder.
I'm struggling with that notion because when you make an offer to buy people's shares, it's not you're not making a stark demand of surrender without compensation. It's basically a bargain, right? And you can test it. If the price was low, they will not accept it. It's because the price was high. That's why they accepted it. The real question is, how come your directors never bothered to pay a dividend? Why didn't they pay a dividend? Why were they sitting on this huge cash balance? What I've just done is release the value for you. You should be thanking me for giving you money, right? And that's what I've done. I've come to the rescue. So if that is the case, and shareholders' interests are not affected, creditors' interests are not affected, then is there any reason why we need to prohibit this transaction? I know in your case it sort of feels like it does not pass the smell test. Yes.
But it makes sense if all the interests
exactly. And therefore, the prohibition does not apply. When we look at the law, you'll see that there is a so-called exception. I would say I don't even need the law to tell me that exception. I can work it out that it should not apply, right? And I'll start with the points you raised, which is that, listen, creditors are protected. We have distribution rules, right? There is no law that says you cannot pay a dividend if you have distributable profits, right? So what's wrong in me doing this? But I suppose the law had to be drafted that way to make it explicit, because there will always be some people like you who will protest and say, no, it doesn't pass the smell test. You need to send them to jail. And the courts basically say, when you're interpreting a penal provision, you need to be careful. Don't interpret it too widely. If there's a provision that can give people a criminal record, you don't sort of interpret it too widely. So you see the idea of being narrow when construing the provision being talked about by the courts. Okay. Does anybody have any questions so far?
Is there any difference in giving the financial assistance before the transaction, or
we catch it before, we catch it after? So the example I gave, right? The example I gave about the pledge, right? Was so this was assistance given. Obviously, they didn't realize they were giving assistance. So they had entered into the share purchase agreement, and then the pledge had occurred, right? Occurred subsequent. So you would say, okay, they gave the assistance later. But even if they gave it before, it doesn't matter. And you see actually the section. If you look at the section, if you turn, it would be good if you could turn to section 677. You'll see that it catches it on both sides. Yeah.
I have a general question about the applying of the rules. Does it only apply to the acquisition of yourself, or would it also apply if you insert a parent company and then another company, and then you assist the top level company in buying your parent company, basically?
Yeah.
Would that also?
So the way it works is that if the subsidiary is incorporated abroad, then you would have extraterritoriality issues, right? If the subsidiary is not incorporated abroad, then the prohibitions would apply, right? So let's imagine it's a public company. I mean, when we look at the sections, you'll see how it works, but it's pretty clear there. I mean, if you look at it, then it would appear that, you know, yes, it will catch. And that's why I started by telling you that, well, it really depends. If it's extraterritorial, it will not. And the reason I say this is because of a case on your list called the Arab Bank case, where there was the giving of financial assistance. So in that case, what had happened was that the parent company transferred assets to the subsidiary, which was abroad. And then somebody was about to acquire the shares of the parent company, and the company abroad, the subsidiary, gave that person financial assistance, right? And the law is that there should be no financial assistance for the purchase of your shares. So there should be no assistance provided by you, the parent company, or your subsidiary, right? Because the law catches that. However, because the subsidiary in this case was incorporated abroad, the court basically said, well, when we talk about subsidiary, it cannot mean a foreign subsidiary. Because if it does mean foreign subsidiary, it means that our law has extraterritorial effect, right? Which it does not. It was pointed out to the judge that in that case, people could drive a coach and horses through a provision by taking the simple expedient action of transferring assets to the subsidiary. And the judge said it would take an unusual combination of cunning, farsightedness, and whatever to do this. Well, of course, it can happen. But he then said, well, if that's the case, if it's so obvious, then the way we would do it would be to say that the parent company has, not the foreign subsidiary, but the parent company has granted financial assistance indirectly. Because the law says it is unlawful to grant financial assistance directly or indirectly. And I remember in one of the examination questions, this was tested. So the point you raised was tested, and the facts were such that we wanted the students to identify indirect financial assistance. So in that kind of situation, somebody who says, well, this kind of financial assistance is not caught, right, because of the Arab Bank case, right, would, be getting a distinction, maybe a low distinction. And the other person who says, well, although it wouldn't, although it will not be caught, there would be a big loophole. And because it's so direct, it's so clear to us, this would be regarded as indirect. Now, that kind of person would be getting like a 75 to 80, right? So that's how that goes. Yeah. Previously, the way the formulation was worded, it was kind of broad. It was unlawful to give financial assistance in connection with the purchase of shares, right? In connection with the purchase of shares. So, and that was too broad. It caught too many things. So now what we did was to amend it to basically say that it's unlawful to give financial assistance for the purpose of acquiring shares. So we now have a much narrower definition of it. And also, so let me just pause here. Assuming we're dealing with the purchase of convertible securities, assuming we're dealing with the purchase of convertible securities, what would the position be? So imagine the company gives financial assistance to somebody to buy its convertible securities.
That's the one we talked about a few times ago, wasn't it?
Yeah.
Well, in relation to part
Yeah, in relation, so in a different context, yeah. So,
It's a dead instrument.
yeah.
But then again, I'm just, based on the discussion last time, does it depend on the mechanism, the way in which it's going to be converted?
Yeah, yeah. So exactly. So, if the courts basically, I mean, you're spot on, and it's kind of similar to what we've just talked about, which is the courts have it at the back of their minds that some people could try to bypass the relevant statutory rules, so they just, even on public policy grounds, they need to be alert to this. So I suppose what they would do here would be to look into the conversion mechanism. Yeah, the Coppertine and Mosley, yeah. So, but remember, it's in a different context, but it's the same judicial policy. So you have a number of cases. You have a case called Ray Bradford and Coppertine Mines, if you remember the judgment of Cozy Howden, yeah, where it says never say never. Yeah. So
just a question of time frame.
Well, no. It's not just a question of time frame, but obviously the time frame, and because you're talking about conversion values. I mean, in a simple world, if you buy, so let's imagine convertible debt securities were issued last month, and immediately convertible into shares, and then the company then gives you $1 million. And then you take the $1 million, you buy the debt securities, and then immediately convert it, right? That would be pretty clear what you're doing. Now, but if it's a bit more complicated than that, then it then means that opposing counsel can, say, well, this was a debt security. A debt security is not a share, and we can't wish it to be a share, if it's not a share. Do you see? So it really depends on the facts that you are presented with. Then what if, okay, you know what? Let me turn to the provision itself, so that we have that in front of us. Okay, so let's ship this show. I'm just trying to, my thing has disappeared. I wonder what. Oh, okay. That's fine. Okay. Sorry, I just need to get these guys down here. Hi, hello? Sorry. Yeah, hi. I called from S-106. I spoke to a gentleman about the cable, the iOS cable. Hello? Uh, yeah, yes, I spoke to you. Hello? Yeah. Is it the iPad cable? So yeah, so the gentleman said, yeah, no, I spoke to him because I've already started the class and I need it for the charger. And he said he'll bring it down. Yeah, so I've just been waiting. Okay, okay, please, thank you very much. S minus 1 point, that's right, yeah, thank you. Okay. Sorry about that. Yeah, okay, so I thought it would be good to just sort of have the provision in front of us. Um, the thing about the provision is that it appears to tell you the meaning of financial assistance, right? By itemizing what could be considered to what is considered to be financial assistance. So it says financial assistance means financial assistance given by way of gift, and it goes on and on and on. Now, I would say that this is not a meaning of financial assistance. In fact, there is no meaning, right? So it's misleading to think that this tells you the meaning. I'll give you an example. Imagine you are trying to do a takeover of a target company. And so let's imagine the target company actually wants to take over. They were the ones who invited you because they have financial problems. And they know that if they continue this way, right, unaided, they'll go into insolvent liquidation. And you say, listen, I'm not interested in your company. And you try to the target persuades you. And then the target says, you know what, we really believe our company is great. We have some difficulties now, but our company is great. And we will pay your accountants to do due diligence, right? So you don't even need to worry. You just appoint your accountants, the PwC, we will pay them. And if PwC tells you it's good, then you decide. And PwC then starts its work, and later the target company pays them maybe £200,000. And then on the basis of their report, you decide to do the bid, right? You decide. And the question then is there unlawful financial assistance? Now, presumably your starting point would be, yes, let's go to 677. It tells us what financial assistance means. Now, how do you put it within 677? Is it a gift? It's not a gift. Is it financial assistance given by way of guarantee, security, or indemnity? It isn't. Is it given by way of release or waiver? It isn't. Is it a loan? No. Is it innovation or assignment? No. Then we get to D. Any other financial assistance. What does that mean? That's open-ended. Any other financial assistance given by a company where the net assets of the company are reduced to a material extent. Now, if this company has financial difficulties, and the company is paying out $200,000, then there is a reduction, right, in its net assets to a material extent. If the company is insolvent, then any reduction will be caught. So if you look at B, or the company has no net assets, so the company has negative reserves, that means just 1 penny, right, would be caught. Now, what this means, what this example means, is that D, any other financial assistance, is open-ended. Is open-ended. So we would then say that the support you gave to this purchaser of your shares, right? And what was the support? Paying the bill of PwC, which enabled them do this, falls on the D. It is financial assistance. It's not been defined by A, B, C, but D tells us any other financial assistance. And because it falls within D, the only question we have to ask is one of materiality. Is it material? So we only ask that question if the company has net assets. If the company has no net assets because the company is insolvent, then we don't even need to ask that question. Once we arrive at the conclusion that there was financial assistance, we don't engage with the materiality question. This example serves to show you that notwithstanding the clear, ambitious stance taken by the draftsman when he says, let me tell you here what financial assistance means, there is nothing there to tell us. All it does is to start by saying that a gift would be, a loan would be, a security would be, but any other thing could be, right? And that's why this creates a lot of problems in practice. Because if it's so clear, then we already know. Any lawyer would know what a gift is, right? You give something, you give something without any kind of consideration. We know what a gift is. We know what security is. So that's D is the real problem. And if you think that the example I gave was a bit too far-fetched, then I would say look at the case of Charleston, because exactly what I talked about occurred in the Charleston case. So Charleston and SWP, right? Charleston and SWP was precisely what I just described, a takeover that fell foul of this provision. And the other point to bear in mind is, in regard to the meaning, is that if you go back to the jurisprudence on the provision, and the jurisprudence, as far as the Charterhouse case is concerned, it's valid, even though it was decided in the 80s based on the position before the change. If you look at the Charterhouse case, you see that it says that there is no definition, right, of giving financial assistance, although some examples are given, and precisely that's what we now know, right? It does not define, even though it says means, here a judge is saying means does not mean define. It just means examples, right? These are the kind of things that, lawyers tell the layman, and they say, wow, and they pay you a lot of money. Because, to the layman, when he see means, right? To the lawyer, means may not means, may mean something else. And so that's what Charterhouse says. And then he says here, so this is Hoffman, he says that the words have no technical meaning, and their frame of reference is the language of ordinary commerce. And one has to examine the commercial realities. And this is the problem. When you're doing something, you don't really look at the commercial realities. Because, it's not, if it's a technical thing, it's very easy to spot if you know your law. But if you look at the commercial realities, then it could amount to the giving of financial assistance, right? And in a case like this where there was a surrender of tax losses, you could see how the judges are looking at it. They're looking at it, with that in mind. They're looking at the commercial realities. And then he says that One must examine the commercial realities of the transaction and decide whether it can properly be described as the giving of financial assistance, bearing in mind that the provision is a penal one. Remember what I said earlier, that if you're dealing with a penal provision, you've got to be circumspect in how you construe it. It should not be too widely construed. Then you see the court basically saying that, basically talking about how a sale of an asset at fair value can be regarded as the giving of financial assistance if it gives the purchaser needed cash. Now, this is interesting. Do you think there is a conflict between this and our dividend example? So, somebody sells an asset to the company. The company pays for that asset at fair value, not at another value. So I have parted with my land and I get cash from the company, and then I use the cash to buy the shares. And the court here is saying that could be financial assistance. Now, what's the difference between that and the dividend example? Yeah.
I think maybe if it's an asset that is not needed by the company.
Yeah, exactly. If it's not needed by the company, if the need is not so pressing and all that, right? Then, yes, but then I suppose, you see, we're coming closer to your sort of smell test type scenario. I know you didn't put it that way, because you would say, but the company doesn't need to pay a dividend, right? The company does not need to pay a dividend. In fact, it might even be in the interest of the company not to pay a dividend. So, if the company did not need to pay a dividend, why is that fine? And then here, where you say, well, the company did not need. Do you see? And you may say, well, we have dividend rules to protect. We could say, we have Section 172. For the directors, Section 172 says that, you promote the success of the company. So we have to assume that when the directors bought, this asset at fair value, they were compliant with 172. These were good faith directors, actively, assiduously promoting the success of the company. And if you check them, if you say, check, yes, you were good guys, then why are you now turning around to say, somehow that doesn't count? It's financial assistance. Do you get? Let's take a break here because I need to I've been calling these guys, I just need to go to their office to find out. As I'm here, like my mind is there. Right? You're not getting 100%, even if it looks like it's 100. Okay, so 10 minutes, and then I'm going to deal with them.
Someone else. Why they need origin. Like one in the foreground is nice, I was doing some research and just like but I'm sure squeeze it. I don't
come faceva, come crollava già per i cinesi o in realtà sono loro che sono chiari perché perché gli altri sono metti con sede alle
hard to like it's really hard to even get to the expectations of the it's really demanding. But I guess I'm not up to date. Or I'm sure yesterday. Otherwise, I usually read the whole thing, go to the French. But the time I need to research things that I need to put it with. So the everything for everything. Someone sees your profile and lists it only. Well, I don't know because We don't use that. But a lot of the friends are also were stuff about remedies, like damages, like all that. We have slides for other costs, yeah. And there is something that we're very flexible, it's not like the underlying cost, it doesn't have to be a concept of the same. So we have a certain cost, it can be worse. For managing coverage or there are warranties the legal owner can be the minor. Because we have the minor has legal owner can be the one. And the minor has legal capacity in different countries. So they have full legal personality, but limited legal capacity. They can own they cannot be able to exercise their rights and obligations by themselves. Because they need a representative, something like their parent or their tutor. Because they don't have a parent or a tutor. They get a tutor appointed individually. Property owned by minors. The tutor will say, oh, I'm going to tell you, no, you need a judicial approval to sell a property. You need a judge to take a look at the property, and you need to prove what you need to prove that you're not buying it. But like if I send me a loan, I say everything else about it for 1 year old.
Okay, so let's continue. So we talked about the Belmont case and yeah.
In private equity transaction, when the debt raised by the investor to finance the acquisition is secured in the assets of the parent company. So it is financial assistance.
Yeah, so basically what we now have is a private company exemption, right? So a lot of those transactions are done with private companies, right? And therefore, in the past, what will happen was what we call the whitewash procedure. So so there was a prohibition, obviously. Then the law allowed for a whitewash, but then we got rid of that, and now we created a straightforward exception, which we'll talk about. So what we're doing now is simply to work out the meaning of financial assistance, right? And then after the meaning, we then look at the provisions to see how they're worded and the exceptions. So then, yeah, that takes care of what you said. So just very quickly with the meaning, we're talking about it doesn't matter if the balance sheet of the company is undisturbed, so it doesn't really, right? We talk about that. I don't need to say much. Then it says here, it follows that if the only or main purpose of the transaction is to enable the company to enable the purchaser to buy shares, then the section is contravened. You look at the realities of the situation, and therefore in this case, where they were dealing with a surrender letter, they could not look at it in isolation. Then let me just. So, if we then look, and I just want to turn to the Charterhouse case itself, because that would be useful. And let me just pull this out. So here, we see the court saying that the need to look at commercial realities means you can't consider things in isolation. So if you notice the test, you see the court saying that this must involve a determination of where the net balance of financial advantage does lie, right? So that's the test that you see the court's talking about. Where does the net balance of financial advantage lie? Looking at everything in the round. Then the other bit here, you see the court here saying that here it basically applies this test, and when you look at the application, you see that it looks at the balance of benefits and burdens and tries to make a commercial judgment, right? In other words, you have to sort of get your hands dirty. Then look at the conclusion. Here it says that it makes it unnecessary for him to decide what the position would have been if the transaction had involved a net transfer of value. In this case, because it was a surrender letter and it did it. Right. So, okay. Okay. Now, then the other case is the Charleston case, which I talked about. And I want you to be aware of this, because this is something that sort of comes up. If you see at the bottom what the judge is saying here, let me just expand that. The judge is saying here that the general mischief is that the resources of the target company, remember it was a takeover, the resources of the target company and its subsidiaries, again to answer the question about subsidiaries, remember I said subsidiaries are court, unless of course the subsidiaries are abroad, should not be used directly or indirectly to assist the purchaser. And then you see the court saying that we look at the commercial substance of the transaction. That's really the key thing. And then the other thing here is the court basically says that even if it is shown that you acted in good faith, that does not save it. So the fact that you're acting in good faith, the fact that you've not breached your duty as a director, does not change anything. The key thing is whether or not you have infringed the provision. And then if you look here, you'll see that I talked about certain exceptions. Remember I talked about the case involving the bank. So you see the judge saying here that there are transactions exempted from 153, obviously using the old law, such as the lending of money by a money lending company. But the question is it in the ordinary course of business, right? Okay. And then you would also see here, sorry. You see here the court saying that ultimately the question is fact sensitive, right? The question is fact sensitive. And then the other issue is the other issue is whether a detriment has to be suffered, right? Does the company need to suffer any detriment? Again, you see the court saying detriment is not a requirement. You don't need to show that the company suffered any detriment. Neither do you need to show that the directors breached their duties, right? So essentially it is very wide. And what if the purchase of shares never occurred? Can you infringe the section if the purchase of shares never occurred? You see? What do you think? Yeah.
I think maybe you could if the loan or the something was given with the purpose
Yes,
of
yeah.
share purchase, even if it never happened.
Precisely. Even if it never happened, you'll still infringe it if that was the purpose, right? If that was the purpose. And also, the words are sufficiently wide to cover pre-transactional financial assistance. So essentially what we're seeing here is just the breadth of it. And then look at the last one. Due performance of fiduciary duties is not of itself enough to avoid a breach of Section 151. The reason I'm spending time on the meaning and all that is that this actually controls the jurisprudence, right? So if you're clear about these issues, then it becomes easy to work out any sort of situation, any kind of fact situation that you're presented with, right? Rather than sort of go straight into the law. Now, so how is it? You notice I didn't talk about the unique case because I've given you the facts and I've highlighted the key things. So against this background, now that we know the meaning, now we know how it should be construed, what we want to do is look at the prohibitions in the section. So you see that 677 defines financial assistance, 678 and 679 deal with the financial assistance at the relevant time. So here you're having a situation where if you look at the wording, it says a general prohibition against a public company, right, or any of its subsidiaries, giving financial assistance for the purpose of the acquisition, right? And then 679, it's a general prohibition against a company or its subsidiaries of a private company from giving financial assistance for the purpose of an acquisition of shares. So here obviously it applies to a public company or any of its subsidiaries, and that's why we tend to use private companies for private equity transactions here, right? Because that way you avoid problems with the law. If you look at 679, it's a general prohibition against a public company, right? That is a subsidiary of a private company. So you see, it's a public company, but it's a subsidiary of a private company, right? And the Arab Bank case is the case I mentioned earlier, which then tells us that in applying the term subsidiary, remember that offshore companies are not caught. And so what are the exceptions? The purpose exceptions, basically, they essentially I don't think, no one really uses the purpose exceptions, right? To say that, okay, we're giving financial assistance, it's not really for the purpose of an acquisition of shares, it's not a principal purpose, it's an incidental purpose, right? It's an incidental, that's the way the argument will go, it's an incidental purpose, it's part of a larger purpose. So in the case where this came up, a case called Brady and Brady, where there was a deadlock between two brothers who owned a company, and they literally had to split the company. And in splitting the company, certain transfers were made. Now, those transfers became the financial assistance. Now, but why did they make those transfers? They would say, to save the company, right? And they tried to then use the exception to say, well, the financial assistance was part of a larger purpose, saving the company. It was incidental, right? We're not doing it because we wanted to get around this prohibition. We're doing it to save the company. And the court basically said that no, you're confusing purpose with reason, right? The reason may have been to save the company, but the purpose is the giving of unlawful financial assistance. And the moment the court basically construed it that way, you can't use the purpose exception, right? Because, purpose, reason. That was the reason. The reason is good. But what was the purpose? The purpose was to give financial assistance, right? So I always find it interesting when I'm marking scripts and people are squeezing things under the purpose exception, and I say, okay, the House of Lords, Supreme Court, they've tried, they've not succeeded. And then you now think you can find this, find a way to apply. So purpose really doesn't work. We struggle. Right, so you get that point. Then if you look at the other one, what they call the sort of unconditional exceptions, right? So I say, what they call unconditional, in my view, would be, they should not be exceptions. They're just making an idiot proof, right? To make people not make the mistake, right? Because a dividend cannot be financial assistance. A bonus share, which is a capitalization, cannot be financial assistance, right? They're just trying to make it clear to everybody for the avoidance of all doubt, right? Okay? And then where the assistance is given by a private company. This was the change made in the 2006 Act, right? And the idea basically is to make private equity transactions work, right? And that way, because they did the calculation, they discovered that millions were being spent on lawyers to do a whitewash under the old law, right? Because you needed a whitewash for those private equity transactions. But now that we have a clear exception, you don't pay a dime. Once it's a private company, you do it. And then the conditional exceptions, like lending money, right? And I give you the example, which I'll upload. It's a case called Intercontinental Bank, right? Where the issue there was whether the lending was in the ordinary course of business, right? Does anybody have any questions? Yeah.
Public to private transaction, is it possible to raise debt for the acquisition of the transaction and to secure the assets of the public company?
So you've not converted yet, or have you converted? All right, so because you're changing from public to private. So if you're changing from public to private, have you changed yet? If you've not changed yet, then your characterization as a public company will govern it. In which case, we'll be talking about the general prohibition. But if you have done the conversion, then it's a different matter. Do you see? So I suppose my question to you is, have they converted or have they not? Because you said in going private, yeah.
So the answer depends on that.
Precisely, yeah.
So it would be okay to re-register.
Yeah. People, yeah. People do that. They do that a lot. It's a big issue. It's not issue as a problem, That's why there's a whole business called going private. Right? We tend to use going private in two ways. Sometimes in America they call it going into the dark, but they're talking about transactions where you're trying to sort of get away from the federal securities laws, right? Because you're listed and all that, right? Because they find all the obligations of compliance a bit too onerous, then you go dark, as it were. But that's very different from what we're dealing with here. What we're dealing with is that you want to do a transaction, you find these rules a bit complex, or not complex, but maybe just difficult to deal with. So what do? You go private, right? And it's very simple, right? So when you go private, then you get, because again, it could also affect your distribution rules about share buybacks and things like that. By now you know that there's so much private companies can do with that, right? There are two things people actually do in practice. One is a bit more draconian, which is that you convert your company into an unlimited company. Because, the beauty of an unlimited company is that all these rules just don't apply, right? Because, because once it's unlimited, right, like, capital reduction and all that, in practice, what generally would happen is that depending on what you're doing, you might create an SPV as an unlimited company, right? And then use that to achieve what you, because that way you're bypassing the rules. But in a lot of cases, the examples you've just given, you just do a public to private. And then consequences of a breach. Consequences of a breach. We're talking about criminal sanctions, so it's a criminal offense. But we're more interested in the civil law consequences. The civil law consequences, because if the law says that this is unlawful, what does this mean? If it says this is unlawful, then it means there's civil illegality, right? There's civil illegality, and if there's civil illegality, then if there's civil illegality, then it could have far-reaching consequences. Certainly, certainly it would mean, if you want to, it's usually very good if you want to get out of a transaction. I give the example of the Nyomco case. Sorry, the case involving the SPA, right? Where there we wanted to get out of the transaction, so we basically plead in civil illegality. But as I said to you, I was extending civil illegality to beyond the pledge. What was illegal was the pledge, right? Not the transaction. So when you look at cases like Head and O'Connell and Kenny and Herbert, you see this very clearly. Right? So these are cases dealing with civil illegality, and you see the court basically talking about severability. I'll give you an example. If you enter into a contract with somebody to take out another person, right? So you put a contract on somebody and say, I want you to go bump this guy off, right? The whole thing is illegal. There's nothing to sever, right? There's nothing to sever, right? So assuming there was a contract that, maybe there's a loan agreement tied to it, right? That there's a loan agreement tied to it, and there's a performance-related pay type thing, right? So if you bump up many people, you get paid more money, right? The whole thing is so illegal. Everything, there's nothing to save, right? You can't sever it. I use a very drastic example to illustrate the point. Now, on the other hand, if you have a contract such as this, where statute tells us that the giving of financial assistance is unlawful. That's what statute says. If you look at the wording, the giving of financial assistance is unlawful. So if the giving of financial assistance is unlawful, does it mean the contract, the underlying contract, is also unlawful? Because the underlying contract is separate from the assistance. I entered into, so let's use the pledge example. I entered into a contract, an SPA, to buy shares. Right? There's nowhere there in the contract that any illegality appears, right? And usually in any SPA, anybody who drafts an SPA, I'm sure you've seen these agreements, there will always be a clause that says if any aspect of this agreement is unlawful, that aspect should be cut off and should not. It's a standard drafting technique as part of this boilerplate agreement. So, but the point I make is that there was nothing in the SPA that was unlawful. What was unlawful was the subsequent act, right, of the company pledging its shares. That was what was unlawful. So what does this mean? It means that if you're trying to enforce some kind of security, you will not be able to enforce it, right? Because and usually the way we test this in exams, you go. The company, essentially provides a guarantee to a bank, right? And says to the bank, because the company knows you're borrowing money from the bank, right? So you're borrowing money from Pacific Bank to pay for the shares. Then the company goes to the bank to say, we provide a guarantee, right? To essentially protect this transaction between the bank and the guy. And then later on, maybe things change, there's a takeover or the company's in liquidation, and the bank wants to enforce the guarantee. Then the liquidator says, no, we will not allow you to enforce the guarantee because the guarantee is unlawful. That's the context. So you narrow the illegality to the guarantee, and you can then cut it off. Because even if we're trying to save the transaction, I suppose you would say, well, the transaction too falls. But any good lawyer should be able to apply Kenny and Herbert and work it through. And let's go through it. So you see where the court here is talking about severability. So questions of severability are often difficult, unless, of course, it's the hired assassin example I gave, which is very easy. There's nothing too severe. There are no set rules which decide all cases. To some extent, each case must depend on its own circumstances, and in particular on the nature of the illegality. The law is clear. The law is clear that where the consideration for a promise contained in the contract is unlawful, the whole agreement is void. Right? The whole agreement is void. But where there is no illegality in the consideration, and some of the provisions are legal and others are illegal, then the illegality of those which are bad does not communicate itself to or contaminate those which are good, unless they are inseparable from and dependent upon one another. So it's that, communication, the contamination, as it were, of it, and so I think my point essentially is that it's a question of fact in each case, how far you take it. So if you're confronted with a financial assistance question, obviously once you've worked out that there is financial assistance, and believe you me, it's not going to be as easy as is there a gift, a loan, or whatever. It's going to be a bit more involved. So once you've worked out that there is financial assistance, and therefore the section applies, obviously you want to then ask yourself, well, does the section apply? Are we dealing with a private company or are we dealing with a public company, right? If we're dealing with a public company, then we know, yeah, the section applies in clear form. Then once the section applies, then it's a question of dealing with the liability of beyond criminal liability, right? Because obviously you're not the police. You're not the regulator, right? So beyond dealing with the enforceability of the transaction. So what are the transactions? Now, two transactions, isn't it? In most cases, the underlying agreement and the offending financial assistance, right? So depending on the situation, you could have the two together. This case is saying that even if you have the two together, you can still, depending on the facts, sever, right? In a lot of cases where the two are not together, it's so easy to sever. But that does not resolve the question of directorial liability, because what the directors have done would involve a misapplication of corporate assets, right? So even if the directors are acting in good faith, because remember we did say earlier that notwithstanding the fact that directors have not breached any of their duties, they're acting in compliance with Section 172, blah, 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 they have nevertheless misapplied company funds. And because they've misapplied company funds, therefore, they will have a liability in trust to restore the company, to restore those funds to the company. In other words, the directors should be sued, right? But you should not stop there. You should always look at all those accessories, right? The accessories to a breach of trust. And in a lot of cases where this comes up in problem questions, which we'll look at, the accessories would be the banks, right? The banks, the law firms, those accessories to a breach of trust. Those who have received. Usually, with the case of the bank has actually received something. In the case of, let's say, other professionals, they have knowingly assisted. So things have sort of come through their hands and they've assisted, right? And this is really serious because when you think about the payer, if you kind of, I was talking to people in my M&A class yesterday, and I was talking to people in my M&A class about a corporate governance issue, right? So the issue had occurred in my corporate governance class. Some of you are in the corporate governance class, where we talked about a case. At the beginning when the course started, I was fixated on a JP Morgan case which I was working on, and it really involved something similar, accessory liability, right? Because in that case, JP Morgan basically received money, close to $1 billion, in an escrow account, and then paid out the money on the instructions of a sovereign. And if you looked at the agreement and asked how much money was JP Morgan making, it was very little. I can't remember the figure now, but it was very little. But JP Morgan took this decision and thereby exposed JP Morgan to liability, because we're talking about liability of just under $1 billion, right? Around maybe about 800 something million. And it didn't really go to the board. At least so far, I've not seen anything that does suggest that. Now, that's why we talk about in corporate governance, right? In terms of sort of risk management. But ultimately, we're talking about accessory liability, because essentially, a breach of trust has occurred somewhere. JP Morgan has received it. They facilitated the breach of trust. And today, they're now being held to account. So I mentioned this in class because on Friday last week, the judgment finally came out saying that JP Morgan, because they lost the argument, they were trying to strike out the case and they lost it. So it was carried by Bloomberg, the FT, and the case has just finally has been decided. So I was mentioning that I would send that. So it's really important to consider these accessories, especially the people with deep pockets. And this was made very clear in a case called Salango and Craddock in the context of unlawful financial assistance. So if you look, at the liability issues here, you see that we're dealing with directors' liability and recipients' liability. Right? So if you look at the heads now, we're talking about constructive trust liability. So once you start talking about constructive trust liability, you're thinking about, when we say constructive trust, for those who, by now you've been sort of sufficiently immersed in the common law system, right? So you know that even if you're coming from a civil law jurisdiction, that when we talk about constructive trust liability, we're talking about those people who were not appointed trustees, but who the law now deems to be trustees, right? So a normal trustee would be a proper trustee. But if the law deems you to be a trustee, then we call you a constructive trustee. Now, and the beauty of these accessory liability claims is that limitation rules don't apply. Limitation rules do not apply, right? Because, you know, the problem with many cases, I mean, say contracts, you're talking about limitation period, 6 years, right? Tort. You know, 6 years in the life of, you know, is very, very small, right? Because before things come up, before you finally realize and all that. But with these cases, right, no limitation rules, right? Because the things could have gone on for a long time, and, you know, I'm working on another case now involving Shell, and that's, you know, been working on a lot of opinions and on, you know, just trying to settle the limitation issue. There will be no limitation, and that's a case where about 1.2 billion and stuff is just coming out, and limitation really is a nil issue, right? In these things. So especially if you can get ahead, if you can show that there's accessory liability, right? Because let me put it this way: you could, like in the Shell case, we could plead a tort or plead accessory liability. If you plead a simple tort, then you have the usual limitation period. Right? So we're talking about 6 years. So in that case, you know, if you take, say, the tort of bribery, you know, bribery itself is a tort. People, when people think about bribery, they always assume it's a criminal offense, blah, 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 right? But it's also a tort. So the limitation period for that tort would be 6 years. But if you're able to recharacterize it as a breach of trust, right, then, you know, you're not subject to that. That's the point. You know, I am... are they trying to eject us out so quickly? It's getting... last time, you know, it was like maybe 10 minutes before or so. So, yeah. Does anybody have any questions? Yeah.
About how you can re-register a public company to a private company, would you also then be able to actually go and get the loan from the banks to buy this public company, then re-register it to a private, and then give a guarantee? Yeah, I mean,
yeah. So whatever you do with the banks,
it's a listed company, for example.
Yeah, no. Well, if it's a listed company, it's obviously it will be a bit more involved, right? If it's a listed company, and so you're not going to come across many of those transactions, unless, of course, maybe it's listed on AIM, the AIM market, and there are not many shareholders and all that. Right, because, you know, potentially, if you think about the amount of shareholders that we're talking about. But so usually it would just be, say, a normal public company, or maybe a company with some kind of listing, but on some small market, so the shareholders are not many. Now, in that case, it really depends on how you structure it. Now, it's standard to convert a company from public to private. We'll talk about this subsequently in some of the... Remember, there's a seminar we're going to do where we bring everything together, right? But all you just need are the shareholder resolutions, right? And all that. And so that's not the issue. And the issue really would just be that the transaction you're entering into, i.e. with whoever is funding you, once they understand what the issues are, then your agreement would reflect this. So it's usually not a problem. Right? And what used to be the problem was what was there before, which was the whitewash. Right? And but the moment they got rid of the whitewash and you could have a private company, then it's a standard thing. I mean, the whole industry, in fact, the whole industry is built on this. I always say that the best way to sort of understand corporate finance is to recognize the power of industry. Industry actually creates these laws. If you think about it. Because previously, there was a prohibition on share buybacks, right? This was regarded as evil, right? And today, buybacks are the norm, right? Why do you think the change occurred? It's because of industry. And likewise, there was a prohibition on financial assistance. But the norm in private equity is financial assistance. How else do you do it? You see, so it's so it's not it's not a problem once you know the gateway to use.
Again, I'm just finding in how to contemplate how you can actually just so easily bypass the rules which have been set in stone just by something so simple as like privatizing the company.
No, because then you're not bypassing it. You're not bypassing. The rules are not meant to apply to private companies. The rules are meant to apply to public companies. So if you're now a private company, you're not bypassing it.
And then you can make it public again afterwards.
Yeah, well, well, if you want, but then you're subject to different rules. I don't see this as, because previously, I would even say the previous regime involved some kind of bypass, because then you were doing a whitewash. In fact, look at the term. The notion whitewash means you've muddied yourself and then you're just whitewashing it and all that. But now there's the law allows for this gateway. And if you think about it, if we just kind of step back and think about the value society creates through these private equity transactions, just think about how many businesses have been set up, how many people have been employed. Do you get the point? That if sometimes we lawyers, we look at these things in a very narrow way. I have this habit. I'm sure you guys are going to know this guy's weird. I always go into, if you take the Times, if you have a subscription to the Times, I look at the archives. So I kind of go back like 200 years to look at the debates for the relevant period. And it's amazing, right? So if you look at the debates, let's say around 1855, unlimited liability. Oh my God, the high and mighty were telling us this was horrible. Society will end and all that. Today it's the norm, right? Right? On so many issues, whether it's limited liability, even exchange control, so many things that you see how sometimes we get things so wrong. The bottom line here is that these transactions really create a lot of value, right? And so many people are employed, tax revenue increases. So what's the big deal? That's what I say. What's the big deal? Okay, so we'll stop here and before they kick us out. Yeah, thank you.
Sorry, Celia. Do you by any chance have any sources about this? Because I'm writing a dissertation.
Now I know. Okay, yeah. If you send me an email, I'll be teaching up to 2, so I'm just getting ready for my next class here. So send me an email and put it in the header, right? So I get so many emails, so I can just say the public-private, whatever, just so that I know you need it.
It's very, very interesting.
Okay, yeah.
Thank you.
So, yeah.
Yeah, we can do I think there's a later on the building that we can go all the way up. Oh, okay.
Yeah, I'm just getting ready for a class in this about to start. But if it's quick, so.
I just want to tell you that actually I didn't know you were my supervisor, so for my dissertation. So
Oh, okay.
Yeah.
So do you want us to meet or?
Maybe later because I have to submit the research plan that I didn't talk to you before.
Okay. So maybe if you wanna just. Do you want to send me an email just so that, because I'll be teaching up to 2, so I can look at it. You just give us anything I need to do. Okay, yeah.
sorry, I have just one question about the pledge.
I won't be able to because my class is about to start. I have a class now,
Okay,
and I'm
sorry.
trying to. Yeah, you can. Yeah. So just if you write me or something, right?
Yeah, okay.
Okay.
I'm so sorry that I couldn't print it out. Because it helps
Oh,
me so
thank
much
you
to
very
see
much.
that.
Thank you.
Presentation. After research plan, do you want me to send it to you for you to review in advance, or do you want me to upload it to kids?
No, send it to me. Send it to me. Yeah.
Sometimes it's more like sometimes he's really well, I'm still I really want to go. Well, they have like but then we go out the 23rd of March. Okay, so you can come last week. Okay, I'll be here. Yeah, I really I don't know the 3rd because I don't remember when it starts.
Because the 2 months is like came like not that.
There's one on Wednesday.
Okay,
But the same day. But I'll either work on Thursday or if I go on Thursday, so to the club, and then I'm free for that. Next Sunday. And the Wednesday after that, we have like to call the weekend for the local. I'm going to be working on it. Not this time.
We'll find something.
Oh, yeah.
And the
I will
that
add
goes at 2
somehow.
or 7.
I'm like,
Hi.
when you do, I don't have as well. I know,
Well,
I'm planning to go to your round.
Yeah.
How are you? How are you feeling? How's your leg? I can still.
Alexa, fine, yeah.
Fine. We went working out.